Simon Ekpa'S legal trial in Finland began with a pre-trial hearing on May 31, 2025, and the main trial has now been officially scheduled to start on June 11, 2025, as announced by his legal team. Simon Ekpa is facing charges in Finland over his alleged role in leading an online separatist campaign advocating for the independence of Biafra, with Finnish prosecutors claiming that the actions potentially meet their legal definition of terrorism. Simon Ekpa'S lawyer, Carl Gomez, issued a public statement confirming that his legal team is fully prepared for the trial and confident in the transparency of the Finnish legal system. During the May 31st pre-trial hearing, the court began reviewing evidence submitted by the Nigerian government, which the defense claims is weak, politically motivated, and potentially manipulated. Simon Ekpa'S lawyer challenged the authenticity of the Nigerian government submissions, noting that the Finnish court has decided to reevaluate and reassess all the information and evidence provided before any verdict. Witnesses from Nigeria are expected to testify against Simon Ekpa, with delegates already reportedly sent to Finland, but the defense remains skeptical of the credibility and objectivity of these witnesses. However, a critic has emphasized deep trust in the fairness and integrity of the Finnish judicial system, contrasting it with alleged corruption, bias, and manipulation in Nigerian courts. The defense team believes that Simon Ekpa will be vindicated, asserting that the terrorism and insecurity in Nigeria long predated his involvement in the Biafra movement, which only began around 4 years ago. The critic accused the Nigerian government of fabricating evidence and spreading propaganda to criminalize Simon Ekpa and suppress the Biafra movement. Meanwhile, many critics are with a confidence that Simon Ekpa will walk free, stressing that the international community is watching and the trial in Finland will be transparent, just, and immune to external political pressure. It was a gray morning in Helsinki on the 31st day of May in the year 2025. The air was still, and the steps leading into the Helsinki District Court echoed slightly under the weight of curious journalists, cautious diplomats, and members of the Finnish-Nigerian community. The pre-trial hearing of Simon Ekpa, a Nigerian-born Finnish citizen and political activist, had officially begun. This moment had been anticipated for months. It was not just a courtroom matter. It was a global spectacle steeped in the sensitive tensions of ethnicity, nationalism, international diplomacy, and the collision between political ideology and national law. Simon Ekpa's name had become increasingly prominent over the past 4 years, particularly in southeastern Nigeria, where he positioned himself as a spokesperson and self-proclaimed leader of a faction of the Biafra independence movement. His sharp online rhetoric and vocal condemnation of the Nigerian government made him both a symbol of resistance to some and a dangerous agitator to others. Living in Finland, thousands of miles away from the southeastern towns of Enugu, Abakaliki, Oneka, and Owerri, Simon Njoku Ekpa used the comfort and protection of European free speech laws to push messages that Nigerian officials insist have destabilized their already delicate national security situation. On that last day of May in 2025, inside the courtroom, a heavily anticipated phase of this legal confrontation took form in an initial hearing that lasted several hours. It wasn't just a procedural formality. It was a revelation of the complexities and contradictions that surround this trial. The prosecution, led by Finnish state attorneys working in coordination with Nigerian government liaison, began to present preliminary evidence meant to establish a foundation for what they described as acts tantamount to terrorism under Finnish criminal law. The Finnish prosecutors acknowledged that this was not a typical criminal trial. They were dealing with a case that was as much political as it was legal, and the ramifications stretched far beyond Finnish soil. Simon Njoku Ekpa's defense team, led by his principal lawyer Carl Gomez, a man with a long career defending clients in high-profile cases across Scandinavia, immediately objected to the introduction of several pieces of evidence. Carl Gomez argued that the materials submitted by the Nigerian government were not only weak and speculative, but they bore hallmarks of political interference, manipulation, and outright propaganda. He told the presiding judge in no uncertain terms that the evidence had not been gathered under conditions that met Finnish standards of legality and fairness. What was especially concerning, he emphasized, was the fact that many of the witnesses expected to testify against Simon Njoku Ekpa'S had reportedly been assembled through questionable processes and under suspicious circumstances within Nigeria. During a brief recess, observers in the courtroom noted the striking calmness of Simon Njoku Ekpa'S. He sat composed, his eyes moving deliberately from the judge to his lawyer, and then occasionally sweeping across the gallery where journalists scribbled hurried notes. This was not the image of a man thrown off balance. It was the demeanor of someone who had anticipated every move, every whisper, and every maneuver long before stepping into that courtroom. Whether this calmness came from personal confidence, a strategic performance, or deep belief in the justice of his cause, no one could definitively say. What many missed or perhaps failed to comment on was the symbolic weight carried by the small Biafra flag pinned Simon Njoku Ekpa'S wore on the lapel of his suit. The flag with its rising golden sun over red, black, and green is banned in Nigeria. To wear it openly is to provoke, to declare allegiance to a cause that has long been suppressed by the Nigerian state. In Finland, that flag pin did not carry legal consequence. But in that courtroom, it carried meaning. It was a message not just to his supporters watching the live updates from places like Aba and Nsukka and Asaba, but also to the Nigerian authorities who had gone to great lengths to bring about his prosecution. Carl Johannes Gomez addressed the court again after the recess. He reminded the Finnish judge that the entire campaign of Simonu Ekpa'S only began around the year 2021. While terrorism and banditry in Nigeria had been a growing crisis for over a decade prior. To link Simon Njoku Ekpa'S directly to the collapse of security in southeastern Nigeria, he argued, was to ignore years of structural failures, political marginalization, and ethnic-religious tensions. Carl Johannes Gomez added that the Nigerian state had failed to address long-standing grievances in the region and that people like Simon Njoku Ekpa'S had emerged as consequences, not causes of that vacuum. The prosecution countered by emphasizing that it was not just about historical grievances. They maintained that Simon Njoku Ekpa'S recent online broadcasts, particularly those aired in the days leading up to sit-at-home protests, had coincided with deadly attacks on public officials and civilians. The prosecutors stated that even if Simon Njoku Ekpa'S had not explicitly ordered violence, his rhetoric created an atmosphere that encouraged it. They introduced clips of live streams and social media messages, some of which used inflammatory language that could be interpreted as a call to resistance. Carl Johannes Gomez was quick to interject that Finland's constitution and the European Convention on Human Rights protected freedom of expression. He argued that no specific broadcast presented direct instructions for violent action. He said that political speech, especially from exile, must be given a wider berth, particularly when viewed in the context of government repression. The prosecution responded by asking whether such protections still applied when speech potentially led to human harm. The judge, in a moment that showed the Finnish judicial system's commitment to neutrality, reminded both sides that this was still a pre-trial hearing. The evidentiary burden had not yet been met. She indicated that all evidence, including documents, video materials, and witness testimonies, would be subject to thorough reevaluation before the trial officially began on the 11th day of June. In the quiet moments after the judge's announcement, there was a perceptible shift in the room. The tension had not dissipated, but a temporary clarity emerged. The pretrial hearing had succeeded in exposing the depth and difficulty of the legal questions at hand. More importantly, it set the tone for what would follow. This was not going to be a quick trial, nor would it be easily forgotten. Outside the court, a small group of BIAFRA sympathizers gathered peacefully under the cold Finnish sky. They held placards written in English, Finnish, and Igbo. One read, "Truth cannot be imprisoned." Another simply said, "Justice for Simon Njoku Ekpa'S." Among them were students, migrants, and activists who believed that Simon Njoku Ekpa'S represented more than himself. They believed he stood for decades of Igbo resistance, for the voices silenced since the end of the Nigerian Civil War in 1970, and for the new generation of digitally connected, politically aware diaspora Africans. Meanwhile, within political corridors in Abuja, Nigeria's capital, reactions to the Finnish hearing were swift and divided. Some government officials saw the pre-trial as a victory, a sign that international mechanisms were finally acknowledging their concerns about what they called online radicalization and cyberterrorism. But others worried that the entire process might backfire. They feared that should the Finnish court find Simon Joko Ekpa not guilty, it would embolden separatist movements, not only in southeastern Nigeria, but potentially in other regions such as the Niger Delta and the Middle Belt. Nigerian newspapers and television programs buzzed with heated debates. While pro-government analysts insisted that Simon Njoku Ekpa must be held accountable, civil society voices asked hard questions about Nigeria's own justice system. They pointed out that Nigerian courts had failed to conduct transparent and fair trials involving separatist leaders in the past. They raised the example of Nnamdi Kanu, the detained leader of the indigenous people of Biafra, whose case had been mired in delays, court orders flouted by security agencies, and lack of public access to trial records. These observers asked whether Nigeria was truly in a moral position to ask another country to punish a political dissident when it had consistently failed to guarantee the rule of law at home. Others asked why, if Simon Eka was so dangerous, the Nigerian government had not made a formal request for extradition. The Finnish government had maintained that Simon Njoku Ekpa was a citizen of Finland and thus enjoyed the full rights and protections of that status. Extradition, they reminded, was not only politically sensitive, but legally improbable without irrefutable proof of criminal acts committed under Finnish jurisdiction. Within Finland, the case was increasingly being viewed through the lens of national sovereignty and the limits of global accountability. Could Finland prosecute a citizen for speech acts that occurred online, targeted at foreign institutions, and generated conflict abroad? Did this trial set a precedent that could affect other diaspora communities with grievances against their home countries? As the trial date of the 11th day of June approached, behind the scenes, things continued to develop. A small team of Nigerian government representatives arrived quietly in Helsinki, reportedly including officials from the Ministry of Justice and the Department of State Services. Their mission was to coordinate with Finnish prosecutors and ensure that the testimony of witnesses from Nigeria would meet legal standards. But questions immediately arose about the witnesses themselves. Who were they? Were they selected from the Nigerian military or police? Were they civilians affected by violence allegedly tied to Simon Njoku Ekpa's broadcasts? Were they coerced? Were they compensated? The defense team in several pretrial filings hinted that it would seek to cross-examine these witnesses rigorously. They warned that the entire foundation of the Nigerian government's case depended on credibility. If the witnesses turned out to be partisan, compromised, or contradictory in their accounts, then the prosecution's case could unravel. Meanwhile, in places like Abia State and Imo State, where Simon Njoku Ekpa's name had become almost mythical, rumors swirled. Some believed the Finnish government was under pressure from larger international players, perhaps even the European Union, to treat the matter delicately so as not to appear as harboring terrorists. Others believed that this was a case of the Nigerian state attempting to export its authoritarian tendencies. Whichever version one subscribed to, the sense of suspense and political charge could not be denied. On social media, particularly on platforms like X and Facebook, reactions were intense. Videos of the courtroom were analyzed frame by frame. One video showing Simon Njoku Ekpa briefly nodding to a supporter as he exited the courtroom went viral among pro-BIAFRA circles. Hashtags like #JusticeForSimon for Simon Ekpa and #BIAFRA trial in Finland trended intermittently in Finland, Nigeria, and the United Kingdom. Simon Njoku Ekpa himself remained largely silent in public statements after the pre-trial. His legal team maintained that it was better to let the legal process unfold without distraction. But a few close supporters who had spoken to him in private revealed that he remained confident, calm, and fully aware of what was at stake. He was not just fighting for his personal freedom. They said he was fighting for recognition of a people's pain, for the right to dissent, and for the idea that even exiles have a voice. The Finnish judge, in her closing remarks at the May 31st pretrial, gave perhaps the most important statement of the day. She said that while the court acknowledged the political implications of the trial, it would operate strictly within the framework of Finnish law and the European human rights tradition. This trial, she said, would not be influenced by diplomatic lobbying, political symbolism, or historical baggage. The court, she affirmed, would do what courts are meant to do: seek the truth, follow the law, and deliver justice. And so, as the world turns its eyes again to the Helsinki District Court on the 11th day of June, the trial of Simon Njoku Ekpa is set not just to determine his legal fate, but to probe the broader question of what happens when national struggles cross international borders and when digital activism tests the boundaries of legal accountability in a globalized age. As the trial of Simon Njoku Ekpa approaches its scheduled date of the 11th of June, 2025, a deeper undercurrent of tension continues to build, not just within Finland and Nigeria, but across diaspora communities, international human rights networks, and even diplomatic channels involving the European Union and the African Union. This is no longer merely a trial of one man. It has grown into a symbolic test of how the modern world deals with the intersecting realities of migration, identity, resistance, and political activism conducted from exile in the digital age. In the days that followed the pre-trial hearing of Simon Njoku Ekpa on the 31st of May, Finnish media outlets, usually cautious and reserved, began to reflect the growing intensity around the case. Helsingin Sanomat, Finland's most widely read newspaper, published an editorial that raised difficult questions about how Finnish laws would interpret acts committed online that might have consequences far away from Finnish borders. The editorial did not take a side, but it subtly underscored the importance of judicial independence while acknowledging the diplomatic complexities now embedded within the case. Carl Gomez, the lead counsel representing Simon Ekpa, has told reporters in confidential briefings that the entire legal theory of the prosecution rests on a controversial leap. Namely, that political speech streamed online through platforms like YouTube and Facebook to a Nigerian audience from within Finland could be seen as an act of terrorism if certain Nigerian officials say it had violent consequences. This is the end of our news update. Please click the icon on the top right corner of your screen to watch my next video. You will enjoy it. I will see you again in my next update. Enjoy the rest of your day. Goodbye for now.